There were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion, court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion in limine to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion in limine to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that.
Now, please speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
May it please the court. In my presentation today, with regard to Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me.
Such a bitch.
Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
His style of argument, he's a very, very experienced attorney. He's one of the best. And he lays out his argument for the judge. Your Honor, first I'm going to tell you some background about the witness, then I'm going to go into my argument, and then I'm going to do this, just to give her a little roadmap of where he's going to go. She doesn't like that. And here is the snark. I thought I was snarky. Are you going to tell me what you're going to tell me? Because I don't need to know what you're going to tell me. Okay? Wow. Listen to that again. She was laughing. She was. Like, this is something funny, Judge Canoni? Is something funny, Judge Canoni?
In my presentation today, with regard to Dr.
Listen.
Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead. And I think we can do it. We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing, give each side 2 minutes. We'll see how we do with that. And we'll try and get through this.
And Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
It's taking 30 seconds. I want the court to be super, super clear about this one point. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview, the reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. On the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear, is
I understand what your point is in making
there
it.
was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure
all
that's
right.
clear. Thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question.
Are we going to be pursuing third party?
Yes.
All right. So I'll hear you on your motion, Mr. Brennan, and then a 2-minute response. Jimmy, keep track, please.
Yeah.
Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See?
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Mr. Yannetti. Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium.
Yes.
Thank you.
Please, sir, I want some more.